In what is the newest blow to former President Donald Trump, the 11th Circuit Court of Appeals has just rejected the argument from Judge Eileen Cannon in her decision to appoint a special master in the case of Trump's stolen documents from the White House that were found at Mar-a-Lago. Details. In an unsigned opinion, Chief Judge William Pryor and Circuit Judges Andrew Brasher and Britt Grant wrote that Judge Cannon never had the authority to hear a civil case Mr. Trump had filed with the aim of stopping the use of the documents as the FBI and Justice Department investigated whether he had violated criminal laws against unlawful retention of national defense information and obstruction of justice. So they wrote a 21-page opinion. Here's some notable excerpts from it. The law is clear. We cannot write a rule that allows any subject of a search warrant to block government investigations after the execution of the warrant. Nor can we write a rule that allows only former presidents to do so. Either approach would be a radical reordering of our case law, limiting the federal court's involvement in criminal investigations, and both would violate bedrock separation of powers limitations. In their, the judges also said that Mr. Trump has satisfied none of the requirements that would have to have been met before Cannon could have issued an injunction to block the probe in any way, much less be able to appoint a special master to review evidence seized for a criminal investigation pursuant to this lawful search warrant of Mar-a-Lago. They also explained that the arguments put forth by Mr. Trump's legal team would have had them essentially have to rewrite U.S. criminal law in a way that would have allowed any subject of a criminal investigation to intervene by a civil suit to block the government from using lawfully obtained evidence against them. So basically, Donald Trump was asking for special rules that no one else would get just for the fact that he had once been president. Right. Okay. They wrote, he asks us to ignore our precedents, finding that a callous disregard for constitutional rights is indispensable. He asks us to conclude that a property interest in a seized item is sufficient need for its immediate return. He asks us to treat any stigma arising from the government's access to sensitive personal information or the threat of potential prosecution as irreparable injuries. And he asks us to find that he has no other remedy apart from equitable jurisdiction. And even though he faces no remediable harm, they observed before noting that the acceptance of Mr. Trump's arguments would force courts to oversee routine criminal investigations beyond their constitutionally ascribed role of approving a search warrant based on the showing of probable cause. Our precedents do not allow this, and neither does our constitutional structure, saying that the only remaining possible jurisdiction for Judge Cannon's ruling was that Mr. Trump was a former president. So basically what this all means is that the FBI and DOJ will now be allowed to proceed with a criminal probe into Trump, which is being supervised by Special Prosecutor Jack Smith. So, well, look at that. There you go. But there's more. What happened is that Trump's team had been trying to throw everything at the wall, every legal argument they could find, and they're going to try to see what sticks. Except that they couldn't. And this opinion knocked every single one of those down. The appeals court had defeated numerous arguments raised by Trump and contested by the DOJ about the definition of personal records versus one that fall under the Presidential Records Act, executive privilege, which he doesn't have anymore because it's not in the executive branch, attorney-client privilege, and whether Trump had declassified documents to focus on simply whether Cannon had lacked any jurisdiction to hear the case at all. So they knocked down all the arguments and boiled it down to this one point: whether Cannon has jurisdiction. And they found that she did not. Going back to, by the way, one of the arguments that I think is one of the best arguments I've seen from a hilarity standpoint, from the standpoint of what's really, really dumb and funny. I declassified them with my mind. You know, just by thinking about it, and not telling anyone. Well, then how are people supposed to know if you don't tell anyone? It doesn't make any sense. But again, I guess in Trump's brain, it does. I'd love for him to tell us, oh, wait, what is that? I'm getting some telepathic signals here. Oh, that's what that means. Oh, okay, I got it. No, the whole thing's ridiculous. He doesn't have special brain powers to declassify things. But anyway, that's it. The federal courts have, let's see. They ruled the federal courts only have jurisdiction limited by Constitution and statute and cannot expand their powers merely by judicial decree, which is what Cannon had tried to use, although the process itself is called equitable relief, which is basically just the power judges use to issue an injunction. So basically, put it very, very simply, Judge Cannon ruled, did this injunction, put in the special master, and her justification is because I could. Oh, is that the reason? Yeah, I just thought I could. Huh. Now that sounds a lot like the same argument that Trump had used to justify him taking the documents in the first place. I could. They were there. I want them. I just want to keep them. That's all. Maybe sell them. Some friends. Maybe Saudis. Friends. But I can't. I did it because I can. Well, it's the same thing that he also used to justify grabbing women by the genitals. When you're a former president, they just let you do it. They just let you take whatever you want. Classified material, doesn't matter. I declassify it with my mind. Right here, mind powers. Declassified, now they're mine. I've also made them mine just because I wanted them. No, this guy's entitled. I mean, that's the entitlement mentality of Donald Trump. Like, everything is his. Turns out that's not how it works. And thankfully, the court agreed. The appeals court. And so they're putting a stop to it. That said, Trump's probably going to appeal to the full 11th Circuit, or at least he could. There's an argument whether or not that court will actually take it up. I doubt it. Again, these are just members of the circuit court saying, look, yeah, we're not buying that argument. And again, he could appeal it to the full court, but that's probably not going to go well. And then, of course, he could also go to the Supreme Court. So what's going to happen there? Supreme Court's probably not going to take it either. I would be very, very surprised, since, again, none of them really care all that much about Donald Trump, honestly. Besides, this is not a conservative ideological issue, which means they're very unlikely to take it up. So, there it is. No more special master. The DOJ and the FBI now have access to those documents. They're going to see what they had, what he had, and add to that the fact that along with this, now the House is also getting Trump's tax returns. That's shaping up for a pretty bad end of the week for Donald Trump. And you know what that means. If you're near Mar-a-Lago, you might want to duck, might want to watch out, might want to hide the ketchup.